At the SILF Climate Change Conference and Awards 2025, Honorable former Justice Shri Abhay Oak stated, "We degrade and destroy the environment under the wrong notion that the earth belongs to us. But in fact, some of us are under the wrong notion that the environment belongs to us. In fact, we belong to the environment." A very good morning and warm welcome for our esteemed guests, Honorable former Justice of the Supreme Court of India, Shri Abhay Oak Sir, President of the Vivekanand Education Society, Shri Suresh Malkhani Sir, the Secretary of Vivekanand Education Society, Shri Rajesh Gehani Sir, and Treasurer of Vivekanand Education Society, Dr. Prakash Lulla Sir, and our beloved Principal Ma'am, Dr. Shri Kanchakurkar Ma'am, respected faculty members, and all my dear participants. I, Dhruti Agrawal, a student of the fourth year BLLB, am pleased to host and welcome you all in today's inaugural ceremony of the third Vivekanand Legal Conclave 2025-2026, organized by the Vivekanand Education Society's College of Law. We are gathering here today from 19th January 2026 to 11th January 2026 to celebrate the spirit of law and justice among young legal minds and witness the passionate and diligent advocates within them. The kindling of the lamp marks the beginning of a journey towards development and invokes a path where proficiency and acumen flourish. May Ma Saraswati bless us with wisdom, knowledge, and understanding, and guide us towards a path of righteousness and enlightenment. I would now request our esteemed guests, Honorable Justice Shri Abhay Oak Sir, and President of VS College of Shri Suresh Malkhani Sir, to mark the beginning of this legal conclave by kindling the lamp.
या शुभ्रवस्त्रावृता या वीणावरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्कर प्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा।
Thank you, everyone. Now that the kindling of lamps has symbolized the beginning of this legal conclave, I would like to invite our honorable dignitaries to take their place on the dais. Today, we have with us Honorable former Justice of the Supreme Court of India, Abhay Oak Sir, President of the Vivekanand Education Society, Gehani Sir, Secretary of the Vivekanand Education Society, Shri Rajesh Gehani Sir, and Treasurer of Vivekanand Education Society, Dr. Prakash Lulla Sir, and of course our beloved Principal Ma'am, Dr. Shri Kanchakurkar Ma'am. So let us all welcome them with a round of applause. Sirs, ma'am, we are eternally grateful to have you with us today. Thank you. Now it gives me great pleasure to invite Suresh Malkhani Sir and Rajesh Gehani Sir and Prakash Lulla Sir to please felicitate Shri Abhay Oak Sir for gracing us with their presence and adding immense value to this event. Thank you, sirs. Now I would like to request our beloved principal ma'am to kindly welcome the president of Vivekanand Education Society, Shri Suresh Mathani, sir. Now I would like to request principal ma'am to please welcome the secretary of Vivekanand Education Society, Shri Rajesh Vihani, sir. Please welcome treasurer of Vivekanand Education Society, Dr. Prakash Lulla, sir. Thank you, ma'am. Sirs, all of you have been a guiding light for all of us, so thank you. I would now like to request Mr. Ayush Yadav, the General Secretary of Vivekanand Education Society's College of Law, to facilitate our beloved principal ma'am, Dr. Shri Kanchapurkar ma'am, who has been a source of strength for all of us. Thank you, Ayush. Moving forward, I would like to take you a moment and take all of you down the memory lane of the evolution and success of Law Fest organized by VS College of Law in the past few years. The journey began with the moot court competition being held at the state level. The first edition was a remarkable success, and it paved the way for the subsequent editions. It wasn't long before it evolved into a national level moot court competition, and just a few years prior, we decided to elevate the event further by transforming it into a grand law fest. The third Vivekanand Legal Conclave, expanding its scope and significance. This year, the theme is Environmental Law and Vision 2047 towards a climate resilient India. To remind us that the environment is how we live, and without it, our existence is for naught. The competition we will be hosting are 8th Hashuji Advani Memorial Intercollegiate Moot Court Competition, the 3rd Intercollegiate Client Counseling Competition, 3rd Intercollegiate Debate Competition, and the 3rd Intercollegiate PR Crafting Competition. This prestigious event has been graced earlier by some of the greatest legal luminaries, including Honorable Justice Riyaz Chakla, Honorable Justice Revati Mohite Dere, Honorable Justice Karnik, Honorable Justice J. N. Patel, and many more esteemed individuals. Their invaluable contributions continue to inspire and shape the future of law in this college as well as in our country. It is now my privilege to invite our beloved principal ma'am to address us and share some words of wisdom.
Respected Chief Guest, Honorable Justice Shri Abhay, distinguished dignitaries on the dais, Shri Suresh Mathani, Advocate Shri Rajesh Gihani, Dr. Prakash Lulla, other trustee members, faculty members, dear students and participants, good morning to one and all. It gives me immense pride and honor to extend a very warm welcome to all of you on the inauguration ceremony of the third Vivekanand Legal Conclave organized by the Vivekanand Education Society's College of Law. Today is not merely the inauguration of an academic event, it is a celebration of ideas, dialogue, and collective commitments to the advancement of legal education. At the outset, I express our deep sense of gratitude towards today's chief guest, Justice Honorable Justice Shri Abhay, one of the finest judges in the history of Supreme Court, whose presence today adds great academic and moral values to this conclave. We are truly honorable, honored by your gracious acceptance of our invitation, sir. Guided by the ideals of Swami Vivekanand and the visionary leadership of Shri Advani, Vivekanand Education Society, established in 1962, is dedicated to fostering excellence in academic, innovative, and holistic development. Total 7 campuses and 26 institutions are there in the vicinity of Chembur, Mumbai. Under the esteemed umbrella of VES, that is Vivekanand Education Society, Vivekanand Education Society's College of Law was established in 2009 with the initial intake of 22 students in 2009 in first year 5-year course of LLB. Over the years, the institution witnesses remarkable growth and currently cater more than 1100 students enrolled in 5 years LLB course, BA LLB course, 3 years LLB course, 4 specialized group for LLM program. Vivekanand Education Society has organized state level, national level MOVCON competition in the past, and this year organizing the third edition of Vivekanand Legal Conclave. The 3 days Vivekanand Legal Conclave aimed for bringing together young legal minds, scholars, practitioners to explore the evolving role of the today's generation in shaping progressive, just, and developed India. The conclave also aims to inspire student participation, promote critical dialogue on contemporary legal challenges, and encourage innovative thinking aligned with the Swami Vivekanand's vision of youth empowerment and national development. I'm very glad to see that our competition receives overwhelming responses from different law colleges all across the country. The conclave comprises of, as our already have mentioned, that it is national level programs are there. So it is moot court, client counseling, debate competition, PIL drafting competition. All these competitions will be conducted in these 3 days. Such events have provided a platform for interaction with the learned judges and the senior advocates. I take this opportunity to appreciate the untiring efforts of our faculty in charge members, Dr. Rajwant Rao sir, organizing committee, other faculty members, student council members, and especially the staff, admin staff, Mrs. Prerna Bhandari. I specifically recommend these 2 names because we know that we all know that this is not possible without their hard work. I sincerely hope that again one more thanks to our trustee in charge, Sir Gyani sir, who is continuously supporting us for the conducting such a big programs in our college. I sincerely hope that the Vivekanand Legal Conclave will foster the meaningful discussion, generate innovative ideas, and contribute constructively to the participants. With these words, I once again welcome all our distinguished guests and best wishes to the participants. Thank you. All the best.
Thank you, ma'am, for your encouraging words and visions for the future. It has motivated us to bring out the best versions of ourselves. Now, I would like to invite the treasurer of Vivekanand Education Society, Dr. Prakash Lulla sir, to share his thoughts and insights with us.
Adherning Justice Vogue, sir, President Malkani, sir, Gyani, sir, respected Principal, Madam, faculty, and my dear students. Good morning to all of you. And I believe we are very lucky that we have someone like Justice Vogue visiting us. I congratulate all of you. We get to hear such wisdom of words from him. मुझे इस वक्त सुनी किशन चंदानी सर ने इतना बताया कि सर के बारे में उन्होंने जब रिसर्च करी थी कि सर की ड्यू जजमेंट्स का रेफरेंस यूएस और यूके कोर्ट्स में भी दिया जाता है. तो आई कम फ्रॉम मेडिकल बैकग्राउंड, थोड़ा सा इस तरफ से जानकारी मुझे सर के थ्रू ही मिलती है. बट व्हाट आई लर्न इज दैट सर इज नोन फॉर हिज ह्यूमन वैल्यूज, सिंप्लिसिटी, integrity, honesty, discipline. Of course, technical side, is definitely super expert, but these are the core values for which service, respected throughout. So I will not take much time and would like to hear from our seniors. Thank you very much.
Thank you, sir, for your thoughtful and inspiring words. Now, now I would like to invite the Secretary of Vivekanand Education Society, Shri Rajesh Gehani, sir, to share his thoughts with us.
Honorable and respected Justice Mr. Abhay, my President Mr. Suresh Palkani, our Treasurer Dr. Prakash Lula, Madam Shri my faculty, staff, and my dear students. Dr. Prakash Lula informed you certain things about Justice Spoke on the basis of his research. I will tell you something from my personal. What he said in law is known as hearsay, and what I will be telling you is an eyewitness, as an eyewitness. So, Justice, I have known Justice Oak since I started my practice in the year 1984. I started going to High Court in the year 1990, and we happened to sit in the same room in the High Court, room number 18 on the ground floor. Even as an advocate, he used to be very helpful to junior advocates like us. Even if he was our opponent, he used to help us in his own case. That much I know as a personal knowledge and a personal experience. When he was elevated to the High Court, one thing which we saw, that he used to come prepared on the bench, and he used to know every single thing about every matter that was going on before him, even better than both the advocates appearing before him. He knew by heart the page numbers, everything. And his memory is so sharp and perfect, it's a photographic memory. Once he used to read anything, he used to remember. And he used to remember even on the next date. That is what I have personally experienced. His conduct is absolutely above bar. And we always used to admire, even the order, if the order was against us, we used to have the satisfaction that the order is just and proper. So that is the way a judge has. Today you are sitting here. Tomorrow you may be on the bench. After years of practice, you will go on the bench. Some of you will at least. Justice Oak is an example for all of us to follow. Much said about Justice Oak. I will also refer to the etiquettes and the principles of our society, which are in tune and in line with what Justice Oak has always throughout his life practiced. Our founder, Ashuji Advani, he founded this society in 1962, and he selected each of us to become a part of the society, our seniors and we, as well as our juniors who we are selecting based on the principles he followed. One thing was very clear, that our Vivekanand Education Society is not here to make money. And the respect which Ashuji has got from the political party and the political spectrum which he belonged to, and even on the opposite side, is amazing. When we were sitting in the conference room, I told Justice Oak that I will share a story about Ashuji. He had a story which he may share with you, but I have promised him that I will share one story, and I am sharing that story with you also. We had in this Vivekanand Education Society a very complicated matter relating to land, which was stuck with the government in the revenue department. At that time, the government was a Congress government. So somebody told me, go and, I will not name the person, somebody told me, go and meet that minister. And somebody else told me he will not do anything without some consideration. These talks go on in our field. So I said, why not try it? So I went and met him. So he called us in. At that time, our earlier president, Mr. Amar Asrani, was with me. So I told him, Vivekanand Education Society from Chembur, we are coming from there. The Ashuji's institution. He said, yes. What is your word? I said, such and such is my word. It is done. It is done. He did not even listen to me what it is. It is that it is done. Then he told me that when I was a kid, I used to visit Ashuji's one-room apartment in Chembur, and he used to offer tea to my father and milk, a cup of milk to me with 4 glucose biscuits, and he used to insist that I should have that cup of milk and those glucose biscuits. He said that I will repay that cup of milk and glucose biscuits today by doing your work. That kind of a karma yogi our Ashuji was. So with these few words, I will end my talk, and I will leave the rest to Justice O. Thank you.
Thank you so much, sir. But shows that as humans, you can make somebody else's life so much better with little things. Moving forward, it is time to introduce our guest. Our guest today is a distinguished individual whose contributions to the field of law and justice have made a lasting impact and earned him the title of the judge who showed spine. It is an absolute honor to welcome Honorable former Justice of the Supreme Court of India, Shri Abhay Shri a distinguished legal luminary who has significantly contributed to the judiciary. Born on 25th May 1960, Justice Oak did his BSc LLM from the University of Bombay and was enrolled as an advocate on 28 June 1983. Sir's legal career started by practicing in Thane District Court in the chamber of his father, Srinivas Oak. This led Sir to join the chamber of Shri VP Tipnis, a former judge of the Bombay High Court and former Lok Ayukta, where his presence was noted in several important matters and in public interest litigations. It is from this time period when Sir himself was an advocate that I found a very inspiring story, specifically from the year 2002. That was even mentioned in the judgment that Sir was appearing for by retired Justice Shri Khanvilkar Sir. Sir, who was just a distinguished advocate at that time, had already gotten the case ruled in his favor. But when he realized that there existed significant binding precedents against his client, he did not hesitate to do the right thing. And he reopened the matter to present his findings before the court, which led to his case being dismissed. This was a commendable act that is even remembered years later, and is one of the first showings of the Sir's guiding principle, which is before you are a mouthpiece for your client, you are an officer of the court. Seeing Sir's dedication to justice and excellency in over law, he was elevated as additional judge of the Bombay High Court on 29th August 2003. From there, Sir was appointed as a permanent judge of the Bombay High Court from 12th November 2005. Sir took oath as the Chief Justice of the High Court of Karnataka on 10th May 2019, which then led to him taking oath as the Judge of the Supreme Court of India on 31st August 2021. Sir retired from office just last year on 24th May 2025, leaving behind a legacy that generations of lawyers shall be privy of, as he inspired others with his strong support for the rule of law and essence of law, unwavering at times of overwhelming dissent from others. Sir has time and again been recognized as an environmentalist due to his firm and vocal view taken to protect and preserve the environment. His judgments and views on various issues such as illegal tree felling, use of firecrackers during festivals, solid waste management, and more paved the way for a greener and more environment-friendly India, showing us how to uphold the theme of this legal conclave. Sir, you have not only added immense value to this event, but also served as a beacon of inspiration for all of us. It is an honor to have you with us today. And I'm deeply privileged to invite you to come forward and share a few words of wisdom and enlightenment with us.
Good morning and namaskar. It is my privilege to be here in the law college run by late, in the name of the society founded in the name of late Shri. In one sentence, I will say that Ashwiji was a model of honesty, integrity, and simplicity. He occupied post of Urban Development Minister, Revenue Minister, but he continued to stay in one room tenement in the same place. So he is a model of these three highest qualities. Mr. Suresh Malkani, the chairman of the society, Mr. Rajesh Gihani, Dr. Dullah, Professor Kanchan Kulkar, members of the faculty, and young students. I must compliment the college for taking up subject of environment law in the context of Vision 2047. It's such an important subject present day, as you must be reading that even in city like Mumbai, EQI, air quality index, is ever rising, indicating huge pollution in our city. This is so about practically all major cities in the state of Maharashtra. So within short time, Mumbai will compete with Delhi when it comes to pollution. Of course, Mumbai has one advantage of sea breeze, so it drives away the pollution. So it will take some time for Bombay to compete with Delhi, and therefore issue of environment is of great deal of importance. And all the competitions are going to be on the issue of environment. Student friends, I want to remind you of a chapter on fundamental duties. There is only one article on that chapter, that is Article 51A. Clause G of Article 51A mandates that it is the duty of every citizen to protect and improve the environment. Now, environment has many facets. It is about forests, it is about our lakes, it is our rivers, it is about the trees. It has facet of noise pollution as well as air pollution. There is a water pollution. So what is important is, it is the fundamental duty of every citizen of India to protect and preserve the environment. And I want to tell you that this provision has direct nexus with Article 21 of the Constitution. As all of you know, Supreme Court has given a very wide interpretation to Article 21. It's not only about right to survive, it is right to live with dignity, right to live with human dignity. It is right to live meaningful life, and therefore it has many facets. Right to privacy is integral part of Article 21. Similarly, right to live in pollution-free atmosphere is also a right guaranteed under Article 21. Now, Article 21, as you know, is one of the most important liberties granted to citizens of India. And please remember the difference between Article 21 and other articles. For example, Article 91, the fundamental rights are available to only citizens. Article 21 gives fundamental rights to everyone who stays in our country. So, since there is a fundamental right under Article 21 to live in pollution-free atmosphere and to live a very dignified and meaningful life, if there is a pollution of air, water, and noise, no citizen can live meaningful life. No citizen can live dignified life. And therefore, there are laws related to environment. And if we commit violation of those laws, it may amount to violation of fundamental right guaranteed under Article 21. And to all young students about one more thing. right to health is also part of Article 21. So if we have pollution of air, water, and noise, our right to get health also gets affected. You must read material on that. The noise pollution can have a very devastating effect on human body, not only on your ears but the entire human body. The medical research has proved it. I need not talk about effects of water pollution and air pollution because we see huge rise in diseases of lung due to air pollution. So therefore, subject of environmental law or environment is very important. It is dear to every citizen. And as you grow old, you learn various principles, polluter pay principles, precautionary principles, and so many principles which govern the law relating to environment. Now, we are going to have competition consisting of debate, moot court, PR drafting. This will be, and clan counseling. This will be all on environment. Before I deal with these four competitions in which you are going to participate, I want to tell you something very important. Today we talk about striking balance between development and the laws related to pollution. That concept needs greater elaboration. Now, young generation of students will have to look into it and answer the question: can we have development at the cost of environment? Can we have development at the cost of air and water pollution? This is one question. All the students will have to answer. There are other serious issue. Can we have pollution caused by celebration of religious festivals? That is also one more issue. Because if environment is given paramount importance, which has direct connection with fundamental right under Article 21, can we have any activity which damages environment? Young student began by saying what I said some time back, that environment doesn't belong to us, we belong to the environment. And the question is whether as human beings we are right to damage the environment. Where today if we damage the environment, we are spoiling the lives of our future generations. And when it comes to duty of preserving and protecting environment, more responsibility is on those who work in law fraternity because they are on higher pedestal than common man. They know the law, they know the constitution. And therefore, more responsibility is on you young students to ensure that this fundamental duty of protecting the environment, protecting and conserving the environment is followed by every citizen of India. Now let us come to the competition. Now one more important facet of this competition is client counseling. I am sure that most of you will join traditional legal profession. In fact, wherever I go, as a maybe for delivering guest lectures or such events, I always encourage the students to join traditional legal practice. I encourage some of the students to join judiciary because conditions of service in judiciary are not as bad as it used to be about 30, 40 years back. And I always believe that the traditional legal practice is the real challenge for legal minds and for young law graduates. And one more thing I want to tell you, after being part of the fraternity 20 years as a lawyer and almost 22 years as a judge, that now today in India, legal profession, the traditional legal profession, can be said to be the most lucrative profession we have. And therefore, it is very important for some of you to, or most of you to think of joining traditional legal profession because traditional legal profession is one profession where you get opportunity to serve common man. You get opportunity to serve society while you earn handsomely. Of course, there is struggle involved in traditional legal profession. You got to have a lot of patience. Two early years are always challenging years. So, practice, client counseling is very important. Now, What is the meaning of client counseling? Now you must first understand why a client goes to their lawyer, to a lawyer. Client goes to the lawyer because client feels that injustice has been done to him. Injustice may be of various categories. Some client may feel that somebody has committed offense against him. Somebody may feel that his right is taken away, right to property is taken away. So first and foremost duty of a lawyer when he gets a client is to ascertain from him what is his precise grievance, what is his idea of injustice suffered by him. And first we must understand the grievance of the client and then take all facts, because it is very important for a lawyer to possess all the relevant facts relating to dispute in which the client is involved. Because unless you have proper facts and all the facts, you won't be able to draft a case for him. Therefore, it is very important for you to see that you inspire confidence in the mind of the client and client discloses to you everything. Because you must also know what is against the client, especially in criminal cases. And as a lawyer, it is your duty to tell the truth to the court, and therefore you must ensure that the client tells you the truth. After the client tells you the truth, after client tells you his grievance and you understand the grievance, then as a lawyer, it is your duty to apply your legal mind. See where the client stands in terms of law. And if you find that the client has a weak case, it is your duty to inform the client that look, you may not have that good case because this is the position of law. You can explain to him in simple words. Because you have to be honest to the client. I used to go and teach young lawyers in this basic legal education or continuous legal education programs. So the lawyers used to ask me, sir, if I tell the client that you cannot have good case, why would client retain my services? I used to always tell him my own example in profession. I used to follow this practice. Tell the client very honestly. And not even 10% of the clients would go back. Because you can always tell the client that this is the legal position, this is where you stand, but I'll do best for you. So the conference with the client, the counseling of the client is the most important thing. Unless you have proper instructions from your clients, unless you know the entire case of the client, you won't be able to effectively put it before the court. So that's great deal of importance is attached to this. Now let us turn to PIL drafting, because a client will come to you to file a PIL. So how do you draft PIL? Now by this time you must have studied constitutional law. You know the difference between the traditional concept of locus standi. Those who don't know what is locus standi, the right of a litigant to approach the court, that's locus standi, because the traditional concept is that I have locus standi to file a case if I am directly affected by something. Only then I can file a case. But from 1980 onwards, concept of locus standi was considerably relaxed, because the judges of the Supreme Court noticed the problems in modern India. You must be aware of that case, Sunil Batra's case, where he wrote a postcard. He was a prisoner in Tihar Central Prison. And in those days, the condition of Tihar Central Prison was very pathetic. So he wrote a postcard to the judges of the Supreme Court. And that postcard was treated as a writ petition under Article 32. PIL was not a nomenclature used in those days. A committee of very senior and distinguished lawyers was appointed. They were told to visit Tihar jail. And they submitted a report about the conditions in Tihar jail. That is where the Supreme Court started enlarging the scope of locus standi. Then comes the Asian workers case. You were not born at that time, students must have not been born. In 1982, there were Asian Games in Delhi. It was a very huge event. And for Asian Games, a lot of infrastructure was created. New highways were built, new plants were built, the roads were widened. The laborers who are working for these projects were brought from neighboring states of Haryana, Uttar Pradesh, Punjab. One social organization found that these persons who were brought laborers, they are not even paid according to minimum wages. And then a petition was filed by that institution to the Supreme Court, and Supreme Court expanded the scope of locus standi. Now the scope is that any pro bono organization, pro bono in the sense that those who are not working for gain, any pro bono organization, any citizen who has no personal interest in the subject matter of the case can go to the court and point out illegality which affects the public at large. And please remember one thing, this PIL jurisdiction is so important. I'll give only one or two examples. Taj Mahal. Taj Mahal was saved by orders passed by Supreme Court in PIL filed by MC Mehta. I was lucky enough to deal with that case for last 2 years when we have to order several things like tree sensors, restriction on tree felling, etc. It is only because of the order of the Supreme Court that all industries which are causing pollution in the vicinity of Taj Mahal are ordered to be closed. And that is how the Taj Mahal has been saved. I can give you several examples of PIL in the context of Bombay and especially coastal area. It was Bombay High Court which said that mangroves which protect us from the sea and it protects sea and marine life, mangroves also form essential part of the forest and therefore nobody can divert that forest area for non-forest purposes. The forests in India were saved by judgment of the Supreme Court in case of Godavari, which is again a PIL. So through PIL, several things have happened. Lakes have been restored. Talking about Bombay, Sanjay Gandhi National Park, it was part of it was encroached upon due to the efforts of the court that the Sanjay Gandhi National Park was saved. The courts have prevented water pollution. Courts have prevented air pollution. Courts have stopped illegal use of loudspeakers to prevent noise pollution. So PILs are very important. So when a litigant comes to you to file PIL, first condition for an individual to file PIL, or for that matter, any association or any incorporated body to file PIL is the credentials of that person. So you must find out person who has come to you to file a PIL, what are his credentials? Because you have to satisfy the court that he is a pro bono litigant. What is his background? What is his education? What pro bono work or social work he has done? Because the credentials of PIL petitioner, maybe an organization, maybe an individual, they must form part of the petition. The first paragraph must contain who is the petitioner. Because court has to be satisfied that here is a person or here is an organization which has no personal interest. And looking to the background of that organization or the individual, they have interest of common man in their mind. So it is very important to find out who is the person and what are the credentials of person who approaches you to draft a PIL. Then again, second thing is the same thing. You must find out what is precisely his grievance and how that grievance is not individual. It may be a grievance related to several people. I'll give an example. There are localities in Mumbai, slum areas, some areas do not get water. So somebody approaches you that, look, about 2,000 people are staying in the locality, they don't get water. And because of poverty and other social conditions of the slum dwellers, they can't approach the court. So you must ascertain what is the problem. And it can't be individual case. You have to also satisfy yourself that a person or organization approaches you, they have no personal interest in the matter. I'll give you an example. Somebody comes to you and says that there is an illegal building which is being constructed at a particular place. If the person who comes to you is the owner of the adjacent property, then he will have personal interest in the matter. So he can't file a PI. His rights are infringed, therefore you can file a regular writ petition. So understand the precise grievance, and then comes very important part. You have to really understand and plead in the PIL that how members of the public are affected. Then you have to plead precise nature of violation of law. Which are the laws which are violated? So if you approach under Article 21, if any ordinary right of citizens is violated, our petition under Article 226 is maintainable. You must also find out whether any fundamental right is violated of the citizens. Because all this has to be pleaded in the petition. It's very important to plead all this. Firstly, the facts, that which are the facts which lead to violation of law, which are the facts which lead to violation of fundamental rights of the citizens. And you must also impress upon the court and you must plead that people who are affected are in such a position that they can't approach the court. For example, persistent noise pollution. Common man can't fight with the might of politicians because all these events, etc., where loudspeaker is misused or without permission, loudspeaker is used or it is used beyond 10 o'clock. Common man is not in position to take on people who are influential people. So therefore, proper pleading is important. And last part is proper prayers. You must be very sure what prayers you want. Because when you approach High Court under Article 226, mainly in PILs, there will be a prayer for writ of mandamus or maybe writ of prohibition. Because ultimately, in so many matters, so many PILs, the grievance is that there is a duty under law and constitution vesting in a particular public authority, and that duty is not being performed, and therefore litigant comes to you. So drafting is very important, and unless you are 100% seized of the facts, you won't be able to draft a petition. And please remember one thing: drafting is something which is basic. Because if your pleadings lack material particulars or pleadings lack material averments, so it's the foundation of the case on which the entire edifice is built. And for younger generation, I want to give a piece of advice, maybe unsolicited advice. Don't use AI tools for drafting a petition. I can tell you, sitting in Supreme Court, sometimes we used to notice after creation of human brain, it's a creation of cases. I used to tell the law, see, if you please, AI can give you very misleading results. And we as judges, sometimes I had told the lawyers that look, this is not drafted by you. This is drafted by some kind of a machine. Sometimes I had told the lawyers to withdraw the SLP and bring proper SLP on same cause of action. Because please understand one thing. Human brain is required for drafting a case. I'll give an illustration. Keep aside PIL. Take a case of a suit. You want to file a suit. There is a contract of sale of immovable property executed by proposed defendant in favor of your client. You want to file a suit for enforcing that contract so that defendant can be compelled to sell the property to you. Now, you have to find out the facts because there is already a notice exchange. So, what will be the defense of the defendant? Now, suppose execution or agreement for sale itself is denied. Then you have to find out who are the witnesses to the agreement. You have to ask the client whether witnesses will support you. So when you draft a suit, you have to actually imagine what evidence you are going to need. And if there are 10 witnesses, out of 10 witnesses, how many witnesses will support your client? All this cannot be done by AI. So you must use your own brain, your own capacity, your own knowledge to draft a petition or any pleadings in the court. Don't use AI. In fact, my former law clerks keep on telling me that if you feed facts in AI tool and try to get the case law on the subject, AI tools sometimes give you non-existing case law. So, see, ultimately, AI depends on the data which is fed to the machine or to that software. So, right from day one, don't use AI tools. Don't use AI tools for debating competitions or moot courts. Today, any young student will notice it. There are functions held and there are written speeches read by the speakers. Within 5 minutes, you realize whether speech is written by the man himself or by using AI tools. Same is the case with pleadings. You can immediately recognize that this is creation of AI. And when we come to drafting, please remember one thing. When you draft a petition or draft any legal proceedings, you are not writing a thesis, you are not writing a piece of literature. The language must be to the point, very simple language, very brief sentences, short paragraphs, and your pleading should be as brief as possible. Because judges are expected to go through a pleading. Pleading should not be too long. So you must develop the art of using very simple language. Therefore, I always tell the young students to read books written by Lord Denning, one of the greatest judges the England has produced or world has produced for that matter. Please see his language. His language is so simple, he uses small sentences and is so brief. So that's very important. Now let us come to the moot court. When we talk about such events, Mr. Jehani is here, I think he's 1 year junior to me in law education. In our days, there used to be hardly one or maximum two moot court competitions. There used to be no other event. We had not heard of mock trial, we had not heard of these debating competitions, drafting competitions. So you belong to a lucky generation of students. So you must take advantage of that. So now let us come to the moot court. Moot court, of course, you have to prepare well, prepare by studying the case law, prepare by studying the case material given to you. Again, don't use AI tools there. You can use traditional things which are available, like Supreme Court Online is there. There are other platforms where you get the case law by giving search. I must tell you that there is no doubt that you must be very well prepared in moot court. But the importance of moot court is that you get opportunity to study a case, to work on that,